Well, it is Saturday morning, and I am in the office handling some things for some clients, both in Pennsylvania and New Jersey. It was a busy week for our law firm in both states, and here I am in the office just tying up some loose ends. With that said, they come out with a blog article yesterday regarding the Fifth Amendment and what happened this week with regards to former President Trump invoking his Fifth Amendment rights. And quite frankly, that is something that each and every person should do if they're faced with the possibility of questioning from anyone, especially law enforcement. You want to take that Fifth Amendment right because that really prevents any type of you providing criminal, potential incriminating information to law enforcement or to anyone. Now, understand that the Fifth Amendment, as I detail in that article, which I'll link into this video, it protects you from criminal prosecution. Well, not necessarily criminal prosecution, but providing the government, whether it be at the state or federal level, with additional information which they can use in a criminal prosecution. But it doesn't necessarily protect you in a civil matter, meaning that in a civil case, if you invoke your Fifth Amendment, that can be used against you in the sense that your silence can be deemed to be some type of acceptance of the adverse position. Now, in a criminal case, especially a trial, the defendant is not required to do anything, and you actually receive a jury instruction that if the defendant does not testify, the jury cannot take any what's called adverse inference against the defendant for that, meaning that you can't hold it against someone for not testifying in their own defense. So that brings us back to the Fifth Amendment. In a civil prosecution, that is not the case. An adverse inference can be taken from the fact that a person does not provide a statement in response to an allegation if they simply invoke their Fifth Amendment right. Now, with that said, it's important to understand that obviously monetary damages are far less serious than losing your liberty and being incarcerated. So I don't know anyone who wouldn't settle a civil case or be required to pay some type of damages in the form of monetary damages as opposed to going in jail. So that is the distinction with the Fifth Amendment and criminal prosecutions. In addition, I came out with an article on search warrants, also a topic this week, following the raid of Donald Trump's residence in Mar-a-Lago, Florida, and the search warrants, and really what the government needs, whether it be the state or the federal level, to search your residence. They really don't need as much evidence as people think they need. They need probable cause to believe that some type of crime occurred, and that probable cause, that calculation isn't an exact science. It's what's called a totality of circumstances analysis, and every judge will come down differently just depending on the situation. So that's important to understand. You don't need as much evidence to gain a search warrant as you need to obtain a conviction at trial. Remember that the standard at a criminal case for a trial is guilt beyond a reasonable doubt, whereas to obtain a search warrant or to arrest someone, you need probable cause to believe that a crime occurred and the person who is the subject of that warrant or that arrest committed that crime. So far less standard, more of a civil standard. The civil standard, as I put in that article, is a preponderance standard, so it's much less, and that's why monetary damages are less serious than taking someone's liberty. But if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. The website, gambleandlaw.com. As always, a tremendous resource for you and your family. All my books, my blogs, my videos are available there in one convenient format. Yesterday, we did come out with our weekly update. Talked over 4,000 of our current and former clients in Pennsylvania and New Jersey. Had some fantastic articles in there. In addition, I have an article on polygraph tests and their admissibility in Pennsylvania and New Jersey. It's a very interesting article that I encourage you to check out. Remember, polygraph tests are usually inadmissible in court unless there's a stipulation, but there are jurisdictions that I detail in an article in which polygraphs are never admissible, Pennsylvania being one of them. In New Jersey, they can be admissible, but there has to be a stipulation by both of the parties. My blunt advice is polygraph tests, don't take them because they don't test whether or not a person is lying. They test physical responses, and that's why there's need for those tubes and those monitors, because physical responses to questions can indicate whether or not a person is telling the truth or lying. But there are plenty of situations where that machine can deliver a false positive, and that is the reason why polygraph tests are usually, for the most part, inadmissible court. But if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week, website gambonelaw.com. Please check it out. There's also an article on the website currently about the Deshaun Watson situation, and I give my opinion on that with regards to the 6-game suspension and what former federal judge Sue L. Robinson did in that case. But once again, have a great weekend, and I'll talk to you all very soon.